Hello, everyone. Okay, let's see here. Do I have this muted this time? Okay, hey, we got AK Red Crossbow. We're going to do a sound check. Hi, Alex. Hi, Janice. Everybody give me a sound check. Can I get a yes if you can hear me, please? 1, 2, 3. Good afternoon, Linda. 1, 2, 3. We're doing a sound check. What are my thoughts, Jennifer? We're going to find out. I have not read this. I have a yes from Janice, so we do have sound. All right, guys. What we're going to do is we're going to check on a visual. We'll go ahead and click here. We're going to go, let's see. We're going to go, you're going to need to be able to grab the form, the document that the state responded with. So we did upload that for you. It's at Rubber Ducky Steven Avery Files.com. So if you'll click that, you'll need to type it into your browser right up here. And we can see welcome to the Rubber Ducky Steven Avery Library. We'll go back to chat real quick. Let me see if I can pop this chat out. Loud and clear. Great. Can I get a visual on the welcome to Rubber Ducky Steven Avery Library screen, which will pop off because I'm in the chat here. Okay, we're going to pop out chat, and hopefully I'll be able to keep up with the chat as well as read the document. You'll have to forgive me if I do miss some of the comments just because I'll be very focused on the documents. Okay, what do I got? I've got, aha. All right. We'll widen that out. Kind of match that up. Hello, everybody. Can we, let's see. Do we have a visual? Can everybody see the visual? Okay, we're going to go here. You should be able to see the Steven Avery Library. Looks good. Thank you, AK Red. All right, and Alex, is this a new response? Yes, Sam, it is. And I'm excited to do this. I personally got woke up about a half hour ago with great news that the state has responded. I will tell you what I do expect is a lot of nonsense and them to deny everything. So don't get your hopes up. We don't have a willing response for them, I'm sure. So let's see how they approach their denial. And to do that, I want you guys to follow along with us, either in visual with us, or you can choose to actually pull up this document. And in that, we have Rubber Ducky Steven Avery Files.com. We'll go ahead and post this here for you in the chat. And then you can choose to go right along with us. Yes, this is tense. I am nervous, I'll be honest, just because this is such a big deal. But like I said, please don't get your hopes up too high. The expected response is that the state is going to deny this. So that's what we're expecting. That's what Zellner expects, of course. And so with that being said, we just want to try to figure out how they're going to deny it. Okay, so we're going to scroll down on this front page for those that have joined us on the library. And we're going to choose R.D. Avery Docs Library, and you'll see the file boxes here. So if you want to choose that, we'll give it a minute to load. Take a few deep breaths. Okay, what we're looking for in this list is post convictions, and we have that right here. And we'll go ahead and give it a click. And then we just need to find it within the library. So, we're going to scroll down. It got thrown in here so quick, you guys, it's going to take me a minute. I do have another way to get it, but it is in here. This looks like, let's see. You'll have to bear with me. I should have just left it open for you guys. We've got 3/11/19. That was Zellner's response. Yay. Hi, Donna. How are you? Okay, BB, can you go ahead and post the document for me? I'm not quite sure, or I can open Discord too. I just didn't want to have to open Discord. You have to bear with me, guys. We threw it in the library and we were in such a hurry. You know, we're nervous, we're excited. This is the state. This is their response to us. So we're a little bit um, excited here. I keep coming back to this one. Well, what am I thinking? Why can't we just go over here? Go up to the top. Let's see, modified. And we'll just go down. Oh, this just has the 1 hour ago. Here it is. It just has a strange name, you guys. So it is going to be listed in the library as 200 5CF 000 381 MO11. Actually, it's what Zellner labeled it, so we'll go with it. Let's get this brought up a little bit. No, I'm sure it's not good news. We are expecting a denial. So here we go, guys. Jeannie, I'm not sure what you're having, the other section, what you're talking of. Are you talking about going to the library? How do you get to open it? Um, what you would do, love, is just go to your normal browser and type in Rubber Ducky Steven Avery files.com. So that's not another section. So it's actually a browser, a website. I hope that helps, Jeannie. Okay, guys, are you ready for this? Let's grab a drink, little sweet tea to get us rolling this morning. Oh, I need caffeine. All right. And here we go. Shake our fingers a little bit. Take a deep breath. This is the big moment, guys. Filed 3/29, 2019. Clerk of Circuit Court, Manitowoc County, Wisconsin. State of Wisconsin plaintiff versus Steve Avery. State's response to defendant's motion for new trial based on alleged Youngblood violations. Oh, we got the mailman here, of course, right at this time. You may hear the family, the furry babies kind of let you know. But we're going to keep going. Introduction. Steven Avery seeks reversal in a new trial based on alleged violation of Arizona v. Youngblood 488 U.S. 51, 1988. Avery's motion should be denied without a hearing for the following reasons. His claims are procedurally barred. 2, his claims are not cognizable on collateral attack. 3, even if he this is hard to read, you guys. This is angering me. Even if he could raise a due process claim, he failed to meet his pleading burden. Number 4, his statutory claim, which is not cognizable, is without merit. And 5, the ANDE, rapid DNA identification, is not authorized or approved for forensic use and therefore cannot be used to test the forensic samples at issue in this claim. Now, remember, guys, we're going to stop there a moment. This is the state responding. This is not a decision. This is simply words on paper where they're trying to stop this procedure. The appellate court has the final answer. Do not take this as what is occurring in the court. This is what is being suggested as an answer by the state. They're wanting to deny it. So we're going to back up. We're going to take into consideration what they think or what they're alleging to be their stand in this case. Okay? So this is the state, this is the arguing side, but we have someone listening in. We heard Zellner's side. This is the other half. And this is the response they're giving to the appellate court. His claims are procedurally barred. We'll get into that. His claims are not cognizable on collateral attack. If he could raise a due process claim, he failed to meet the pleading burden. His statutory claim, which is not cognizable, is without merit. The ANDE, which is Andy, the Andy rapid DNA identification is not authorized or approved for forensic use and therefore cannot be used to test the forensic samples at issue in this claim. We're going to come back. Let's just go ahead and hear everything they've got to say, and then we'll have an open discussion afterwards. We'll try to stick to topic. It is frustrating to read such strong words on a page, but they are not deciding. They're just trying to make a strong opening statement. And remember, Kratz did that too. And we know that that was absolutely full of lies and deceit. So let's go ahead and try to get through this document. All right. Avery also requests that the trial court recuse itself from further proceedings in this matter. There is no basis in this record requiring the court to consider recusal. So right there, they're stating that they're not interested in recusing, which is where we ask Judge Sekowitz to recuse herself, and they are saying basically they're not interested. Back to the document. Because the supplemental Wisconsin statute 974.06 motion involves application of established case law, it can be resolved on briefs without need for an evidentiary hearing. Further, there is no need for the court to recuse itself. The state offers the following arguments and begins with Avery's request for recusal. So this section, you guys, hi Daisy Lady, hi Jamie Hart, hi Sam, Lyra. Okay, you guys, what we're doing here is we're reading the state's response. And this section is where we have asked, Zellner has asked for the judge in the case, Judge Angie, to recuse herself because she does express that she has an understanding and a knowledge of a prior relationship on a business level with the court case itself, which is King Kratz and Angie. So there is a conflict of interest being questioned at this time. And the state's response is request for recusal. Avery makes two arguments in support of his request for recusal. First, Avery argues the court should recuse itself because it presided over the civil suit Teresa M. Halbach versus Steven Avery Manitowoc case. Upon closer examination of the CCAP record, the only matter the court presided over was the plaintiff's motion for voluntary dismissal. Judge Sekowitz was appointed on October 29, 2013, after a request for substitution was made on the original judicial assignment. Plaintiff's counsel, Patrick Coffey, filed a motion for voluntary dismissal on November 21st, 2013, and a telephone scheduling conference occurred on November 25th, 2013. The court pointed out that criminal proceedings were still pending. Attorney Coffey asked that the court hold the motion for dismissal in abeyance until the conclusion of the criminal court proceedings. However, 2.5 years later, on June 8, 2015, this court granted plaintiff's motion for voluntary dismissal. There were no proceedings in the civil case dealing with discovery issues or the presentation of any evidence regarding liability or damages. The court made no evidentiary decisions in the civil case. Thus, it is clear the court was not biased in the presentation of any evidence during the proceedings in the civil case. SCR 60.04 subsection 4A does not require a court to consider recusal under these circumstances. Avery relies on disciplinary proceedings against Kohler. The Kohler disciplinary proceedings is distinguishable on its facts and provides no support for considering a recusal. First, and most importantly, in this disciplinary proceeding, the preceding judge in the underlying criminal action, Judge Harrington, voluntarily recused himself. He was not required to do so. The opinion does not mandate a recusal just because a judge presides over both the civil and the criminal cases arising from the same set of facts. In fact, in many of the counties of the state, judges may very well decide a case in family court, juvenile court, and criminal court when the actions rise out of common set of facts. In addition, it is also clear that Judge Harrington actually presided over a trial in the civil case which arose out of the same set of facts underlying the criminal case. The underlying facts in the civil and criminal cases involved claims of fraud by a contractor. The issue in the disciplinary proceeding was whether the prosecutor failed to comply with discovery obligations and the corresponding orders of the trial court. Judge Harrington determined the prosecutor failed to comply on numerous occasions. During the course of the civil trial, it is possible Judge Harrington may have learned the answer to whether certain canceled checks not provided by the prosecutor during the discovery process constituted exculpatory evidence. It is also possible that Judge Harrington recused himself because he found himself at odds with the prosecutor and wanted to ensure that he gave both the defense and the state's fair trial. Let's pause there. There's a statement right there worth rereading. It is also possible that Judge Harrington recused himself because, no, we don't need a system update, because he found himself at odds with the prosecutor and wanted to ensure that he gave both defense and state a fair trial. The case was assigned to another judge who ultimately dismissed the case with prejudice because of the failure to provide relevant discovery. Based on these facts, there is no reason for the court to consider recusal when the only thing this court did was grant the plaintiff's motion for voluntary dismissal of the civil case against Avery. It is beyond argument that the dismissal of the civil case was favorable to Avery. I need to take a moment. It is not beyond argument, in my personal opinion. It is obviously relevant. Excuses as to why this should not happen are beyond reason, in my personal opinion. I am so frustrated right now. But let's take a drink of some sweet tea. Let's say hi a moment. Hi, PCO5. Hi, Emma. You guys, I'm trying to keep it all together here. This is so frustrating. Okay, let the show continue. As always, here's the stage for the state to make all these claims. All right, next. Avery requests recusal because Judge Sekowitz was a member of the Crime Victim Rights Board, the CVRB, with District Attorney Kenneth Kratz during the time that Avery's case was being investigated and subsequently tried for homicide in the winter of 2007. This argument also misses the mark. First, I haven't heard any seconds. I just keep hearing the word first. First. Okay, here we go. First, Judge Sekowitz was not assigned to handle any of the post-conviction motions filed by Avery until Avery filed his first Wisconsin Statute 974.06 motion, Proceed, on February 14, 2013. It is a matter of public record that this court did not receive the judicial assignment for Avery's case until April 11, 2013. The fact that District Attorney Kratz and Judge Sekowitz happened to sit on the CVRB is no consequence. It is also important to note Judge Suckowitz sat on the CVRB as a citizen member and not as a judge. Judge Suckowitz left the CVRB when she was appointed to the bench in the summer of 2010. It is also a matter of public record that District Attorney Kratz resigned from the CVRB in October of 2010. Oh, so they adjust. Oh, so they both were there till 2010. Interesting. It is mere speculation that association somehow biased the court in the handling of Avery's post conviction cases these many years later. Oh, of course not. Oh, no, we couldn't be biased many years later, right? So I got to stop there, you guys. So in 1985, when this all happened, nobody was biased in 1985 because years later, we saw in 2003 a civil case against Manitowoc County years later because they were biased. So right there, are you sure that the state is not just blowing smoke here? I'm pretty sure they are. If anything, they go on to say, it is equally possible the court would look unfavorable upon the prosecution's case, given the conduct leading to resignation of District Attorney Kratz. So that is their response to her recusal. They're basically claiming that it was so many years ago. Yeah, they served on it together, but Judge Angie wasn't acting in her professional sense of the law, and so we should overlook it. No, 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 no. You don't get to take off your judge hat. You are a judge. What you do outside of the proceedings in the room very much affects what you're doing on the stand. And so, no, there's no removal of the honorable judge hat, in my personal opinion. You are a judge at all times, especially when you're dealing with the CVRB. This is definitely related, and also you have your name on the line where the Hawbucks are involved in a civil suit against the defendant. This is not some other case that's related through a relationship, through family. It is the exact case of the Hawbucks civilly suing the defendant, Steve Avery. Judge Suckowitz was the one that signed on the dotted line at the last minute when it got dismissed. Was it in favor of Avery? Um, yes, that was in favor of Avery. Why was it dismissed? Because it was also in favor of what the Hallbachs were requesting. See, keep your eyes on the ball. The Hallbachs requested the dismissal. The judge was siding with the victim's family. It benefited as a result of that decision to the defendant. So let's go ahead a little further here. Um, we'll take a few comments, just a few. We want to stay on schedule. In each other's pockets. Yes, Emma, that's a great statement. I appreciate what you said there. Um, Sam makes a comment. His personal opinion is, he says, I think that the real killer could confess and they'd still keep SA banged up. So I think we all kind of feel frustrated at this point. Heidi does say, don't hate on Wisconsin. There are a lot of us good people here. Yes, yay, Wisconsin. I'm from Wisconsin, and so are a lot of people. We do not agree with state. We are taking a stand against the decision to state to fight this case tooth and nail. And we're going to stay there because even though we're from Wisconsin, the heart of Wisconsin, even, we do not stand behind these decisions being made. She goes on to say, is that the corrupt court system that is ruining our beautiful state. This is appalling. High five, Heidi. I stand with Heidi 100%. If you're from Wisconsin, you stand with Heidi. Please say, hey, from Wisconsin, we stand against the state's decision at this point. So, Preservation and disposition of bone fragments. This successive supplemental motion is procedurally barred. Let's see how they go approach this. In State versus Escalona, Navarra, the Wisconsin Supreme Court created a simple rule designed to limit successive post conviction motions and appeals in criminal cases. A defendant must raise all grounds for relief in his or her original supplemental or amended motion for post conviction relief or on direct appeal. If a ground for relief was not raised or incompletely raised in a prior post conviction motion or direct appeal, it may not become the basis for a new post conviction motion unless the defendant can demonstrate a sufficient reason why the new argument was not previously raised. Okay, we have addressed this through Zellner. The sufficient reason is there was suppressed evidence in the case, which were um, the Bobby Dassey dark web discs that contain all of this during the time that would have made him not a star witness, but possibly an actual suspect. That was suppressed. So we have sufficient reason because that was suppressed by the prosecution. And so we could not, the jury would not have made the same decision based on the knowledge. And so we have right there sufficient reason. Let's continue with their smoke and mirrors here. The purpose behind this rule is clear: the promotion of finality in criminal litigation by requiring defendants to bring all available grounds for relief in a single post conviction motion or appeal, unless there are good and sufficient reasons for not doing so. There's no dispute that Avery had a direct appeal. There's no dispute that Avery's filings are successive and repetitive. There is no dispute that Avery has chosen to take a piecemeal approach to collateral review. And Avery has not demonstrated a sufficient reason for failing to bring all of his claims in a single post conviction motion or appeal. He simply wants a court to treat him differently and not apply the procedural bar. Okay, let's take a minute to breathe, get a drink. That's so frustrating. Yeah, I don't see Steve Avery asking for special treatment here, you guys. Continuing. Any claim for a new trial premised upon the failure to previously test the bone fragments or the alleged improper disposition of certain bone fragments evidence is barred because the claims could have been raised previously on several occasions. The first opportunity to raise a claim regarding the failure to previously test the bone fragments occurred during the direct appeal. Appellate counsel could have raised a claim within the context of ineffectual assistance of trial counsel for not requesting further testing after the FBI report was submitted. Since the planted evidence theory was central to the defense, it could have been argued that further testing might have supported the theory. The second opportunity to raise this issue came when Avery filed his first Wisconsin statute 97.06 motion Pro C on February 14, 2013. Avery raised claims of ineffectual assistance of both trial and appellate counsel in that motion. However, no request was made to test bone fragments to support the planting defense, and there was no claim of ineffective assistance of trial or appellate counsel for failing to raise the issue. The third opportunity to raise any claim regarding the bone fragments occurred when current post-conviction counsel filed Avery's second Wisconsin statute 974.06 motion on June 7, 2017. They're very long-winded, aren't they? Nowhere in this filing, nor in any of Avery's motions for reconsideration filing in the fall of 2017, after this court denied the June 7th motion for post-conviction relief, is there any request to test bone fragments. Despite these failings, Avery could have raised a claim regarding the return of some of the bone fragments in his last supplemental motion on remand. On January 19, 2018, Avery's private investigator, James R. Kirby, filed a Freedom of Information FOIA quiet, please. Shh. Maya, you're fine. It's just the neighbor. Filed a Freedom of Information Act request with the Calumet County Sheriff's Department requesting, among other things, all investigative reports on the Avery case beginning October 31st, 2005 through the date of request, April 19, 2018. State Exhibits Number 3 at 7. The Calumet County Sheriff's Department handled the matter as a public records request pursuant Chapter 19 of the Wisconsin statutes. The Sheriff's Office indicated a willingness to comply and advised Mr. Kirby the cost would be $279.25 at 25 cents per page. On April 25, 2018, Mr. Kirby tendered payment in the amount of $279.25. The reports were mailed to Mr. Kirby on May 29, 2018. Included in the 111 and 17 pages of investigative reports was the report of evidence custodian Jeremy Hawkins detailing the disposition of certain bone fragments evidence. The report was dated September 20, 2011. Deputy Hawkins' report is numbered pages 1114 through 1115, Exhibit Number 2. Current Post-Conviction Counsel acknowledged receiving the investigative reports on or about May 30th, 2018, in our motion and compelled production of recent examination of the DASI computer filed in this court on July 3rd, 2018. Armed with this additional information, current post-conviction counsel could have and should have filed a motion in the Court of Appeals asking leave. We'll give the dogs a minute. The neighbor now returned to his home. Special news via Ducky's home. Okay. Armed with additional information, current post-conviction counsel could have and should have filed a motion in the Court of Appeals asking leave to expand the scope of the remand order issued by the Court of Appeals on June 7th. Quiet, Gretchen. To include claims based on the disposition return of the bone fragments. Counsel failed to do so. Consequently, any claim regarding the disposition of the bone fragments is barred by application of Escalona Navarro. The language in Escalona Navarro is dispositive. And they quote it. If the defendant's grounds for relief have been finally adjudicated, waived, or not raised in prior post-conviction motion, they may not become the basis for a Section 974.06 motion. The language of subsection 4 does not exempt a constitutional issue from this limitation, unless a court ascertains that a sufficient reason exists for either the failure to allege or to adequately raise the issue in the original supplement for amended motion. ID at 182-83, underscore added for emphasis. The motion should be denied as procedurally barred. Come on, Gretchen, I'll help you back up. Come on. You can't cry, baby. We're on live. Gretchen's trying to say hi, so she's got to have her chair right by me, or she cries when I do lives. I can be on the computer all day. No problem. I go to do a live. This girl needs to sit by me. So, okay. We're going to take a moment because my head actually hurts at this point with their... Okay, we have not been given a hearing yet. Just a no and a stamp. We have not had knowledge. She's saying that we signed for this in 2018. We had this form. Zellner is absolutely stating no. We were missing a piece of paper in that, and we did not. So this is, again, smoke and mirrors. When we received these documents and all this, we had no knowledge of all the suppressed information. The fact that these bones were given back to Hallbox, and these bones were given back to not just Hallbox, but the victim's family as their daughter. This means this is their daughter's bones. It was not found on Steven Avery's property. This information was suppressed at the time of trial. Suppression means we could not have known about it. Okay? We didn't have, how can we argue something that is being hidden from us? It's as if they want to play unfair and just expect us to be this superpower, read everybody's minds. No, we're going to play fair. We need it to be played fair, and we cannot go forward without knowing things that are being suppressed. Were Bobby Dassey's computer of the dark web searches being hidden? Absolutely. Who had them? You tell me. In his personal files, Fassbender had them not at work in a safekeeping a place where evidence is kept and stored and protected, but over his personal watch. Suppression. Okay, let's take a drink and let's get back into this and try to focus without letting our migraine take over from their blabbering. Their little smoke and mirrors is not going to work. Even if the claim is not procedurally barred, see right there, even if the claim is not, that right there is an embedded confession. That means it's not locked in. It can still be stated, no, you're incorrect. It's not procedurally barred. So let's continue. That's an embedded confession right there that lets you know that they're trying to brainwash you and all of us into thinking that they've nailed this when they're on very shaky grounds, because they just basically erased everything they said in this entire statement with that statement alone, even if the claim is not procedurally barred. See? It cannot be raised in Wisconsin Statute 974.06 motion. The petition under Wisconsin Statute 974.06 is limited to jurisdictional and constitutional issues. Let's stop there. We have a constitutional issue, guys. That's what we said. So right now, it's limited to just jurisdictional and constitutional issues. That's what we have, constitutional issues. We are being barred from giving a hearing. In this document alone, they're saying deny it without a hearing. Don't let him talk. Keep him muted. Keep him muted. See, that's how they play this game. Avery's motion for new trial based on an alleged young blood violation must be denied because he has no cognizable, constitutional, or jurisdictional claim. At best, he has only a statutory claim, and that is not enough. Avery spends much time and effort arguing the state violated his due process rights when it of some of the bone fragments, disposed, sorry, of some of the bone fragments recovered during the investigation of Teresa Halbach's disappearance and death. Excuse me, sorry about that. Avery relies on Arizona versus Youngblood. This reliance is misplaced. Youngblood and its progeny do not apply to post-conviction proceedings. District Attorney's Office for 3rd Judicial District versus Osborne, 557 U.S. 52, 2009. In Osborne, the court determined there is no procedural or substantive due process to DNA testing of the state's evidence in a post-conviction proceeding. ID at 72, similarly, there is no due process right under the Wisconsin Constitution either, because the due process clause of the Wisconsin Constitution is a subsequent equivalent of its respective clause in the United States Constitution, State versus Manus. Okay. Forgive me, this is the first time seeing this document too. Osborne sought access to state evidence so that he could apply new DNA testing technology that might prove him innocent. Osborne claimed he had a due process right to access evidence during post conviction proceedings so that he could do short tandem repeat STR DNA testing. Osborne asserted that such testing was more discriminating than DQ alpha or RFLP methods that were available at the time of his original trial. However, the Supreme Court rejected his invitation to recognize a freestanding liberty right to DNA's evidence testing in post conviction proceedings. Osborne, at 72, the court determined once a defendant has been proven guilty beyond a reasonable doubt after a fair trial, key word, you guys, fair trial, he does not have the same liberty interest as a free man. Aha. They screwed up right there. Just put that fair trial. We're going to take this because I can't stand it. And we're going to see if we can grab this or not. Yeah. Uh-huh. Let's see if we just do a tweet about this right here because, Lord, you guys. Let's see. Do we have a way to highlight? Yeah. After a fair trial. Aha. Let's save this little thing here in the library so that you guys can go look at this because, wow, really? I have to pause on that. Okay, this is the back end to the library. I'm just going to pop it in there for you guys. We're going to put it in the same, or we're going to go to links and files here. We'll go to the Steven. This is the back end of the library you're getting to be part of right now. And this is how it works. It's on a OneDrive. And I'm putting in, oh, let's see. What do we want to list as? Maybe not a ping, maybe a JPEG. Does that get us a match? GIF. Maybe a TIFF, huh? Okay, let's go back one file. We'll just stick it here and we're going to put it as a ping. State claims based on, we're going to go all caps, fair trial. We'll be tweeting that later together, you guys. And so I'll ask you to find the Rubber Ducky Twitter if you're on Twitter and share that because that's amazing. Okay. I'm going to go ahead and finish this one little section and then we're going to take an intermission break for a few minutes. Whoops. Sorry, guys, not meaning to screenshot that. We'll back up. We'll read this little section and then we're going to take a minute to. That's frustrating. The court determined once a defendant has been proven guilty beyond a reasonable doubt after a fair trial, he does not have the same liberty interest as a free man. ID at 6869. If the Supreme Court had concluded there was a due process right, the court would be short circuiting the many considered legislative responses being adopted throughout the country by state legislation to handle post conviction testing issues. The court further opined establishing a freestanding right to access DNA evidence for testing would force us to act as policymakers and a subs I can't even say that word, you guys, substantive due process rule-making authority would not only have to cover the right of access, but my Murad or something like that myriad of other issues, a lot of other issues. We would soon have to decide if there was a constitutional obligation to preserve forensic evidence that might later be tested. We've already decided that, you guys. We've already decided that. It's state Wisconsin law that you need to preserve the biological evidence. Lord. Arizona versus Youngblood. If so, for how long would it be different for different types of evidence? It's not different types of evidence, you guys. It's biological. Would the state also have some obligation to gather such evidence in the first place? Are they seriously asking these questions? How much and when? No doubt there would be a, are they making up words? I swear. Miscellany of other minor directives. Harvey versus Heron. Horon. I think I said heroin. I meant Horon. I'm just absolutely flabbergasted with the state's response. Since there is no procedure or substantive due process right to conduct DNA testing and no recognized constitutional obligation to preserve forensic evidence that might later be tested, Avery has no basis to claim this or bring this claim in a Wisconsin statute 974.06 Wisconsin statute. Yes, he does, you guys. It is a state law that they are to retain any biological evidence that has been used in a criminal case where the individuals are directly incarcerated due to this evidence. And we have that in this case. Do we have a fair trial? Absolutely no. Why do we not have a fair trial? Because evidence was suppressed that would have taken away their star witness, Bobby Dassey, because he had a motive. He was on the dark web at the, I want to say within hour, 2 hours on the time step of the dark web in the Dassey residence before the victim arrived at the home. We are talking about dismemberment of body in this case. What was he researching at the time? You go read it. If you can stomach that, it's not just porn. Many Americans, many people all over the world enjoy looking at the human body in a beautiful way. This is not that. This is dismemberment and it is child pornography and feces and horrific details. Hours prior, this was suppressed and kept in Fassbender's private collection, which brings a lot of questions we can't touch today. We need another video for that. Um, and was not even made aware to us and suppressed during the actual trial, which is new evidence, which is it's against his rights, his constitutional rights. So far we're in good standings, to be honest. We're going to graze up here on part 3. I personally need to take a moment just to catch my breath. This is a lot of information. This will be a very long video because the state is very long-winded. So with that, I'm going to just go ahead and pause. Please do um, put your questions on the board. When I come back, I'm going to take a 3-minute break. It is 3:05 my time. So, oh, I'm sorry, 3:06. So we'll come back at 3:10, a little sooner than that. I just need to take a breather and collect myself. This is a lot to take in. All right. I know that was probably only 2 minutes, but I just went and broke all my china, just shattered it all to kind of calm down so I can read this for you guys. Um, yeah, let's take a minute here before we continue. Fair trial. What fair trial? Judge Suckowitz, you can't use excuses. The law is the law. If you are involved in a civil and a criminal case, you are not to remain in that position. Can you take your judge hat off? No, you cannot. You are a judge. Do your job. Judges are supposed to be honorable. We call them honorable judge so and so. I cannot say that with your name if you do not recuse yourself. You have your hand in two cookie jars, and it's not to benefit Avery at all. You have denied every hearing. He has not got to speak. Why is Wisconsin afraid to allow this man to speak? I am so frustrated, you guys. I literally had to go scream in a pillow because this is all smoke and mirrors. The state is weak right now. This is the weakest document I have literally seen so far. It is absolutely weak. The means that they're going about this is that they're hinging on certain things, which is that he had a fair trial, that he hasn't had any human rights violated, that there's been no suppression of evidence, that there is no DNA testing. This is all falsified information. This is literally not true that we're reading. It's kind of like saying you come home from work, the kids don't have their chores done. Hold on, let me get my puppy up here. Come on, Gretch, you can be up here. Come on, love. There you go. Okay, guys. It's kind of like saying you get home from work, none of the dishes are done. The house is a disaster, and you go in, and your ceiling fan the globe is broke, and your two boys have been at it, and you know it. They've been acting stupid, and one says, "Well, I was trying to do my chores, but this guy was running around jumping, and he broke the light, and so I stopped, didn't do my chores, and now you got the other guy that broke the light." Shattered your $250 ceiling fan, and he says, "Yeah, but I want to go to the park." It's unrelated. I broke the light when I flicked the light on. No, you didn't. No, you didn't. You broke the light when you went running across and you jumped and your head hit the bulb. We all have kids. We all know how that goes. And this is a kid. The state is being a little kid saying, "Well, you can't do that because he's already been found guilty in a fair trial." That's the whole entire point that we're saying. That's the whole point. There wasn't a fair trial. Okay, taking my soap box off. Are you guys ready to rejoin? I'm going to say hi in chat. Everyone, I did it in caps because I'm yelling out, giving a shout out to all. Oops, what did I do? There we go. Okay, guys, let's continue. Number 3. Even if Youngblood applied post conviction, which it does not, Avery has not met his pleading burden. 2 United States Supreme Court cases address the criteria that courts must apply to determine when the state fail- when the state's failure to preserve evidence before trial amounts to a due process violation. California versus Trombetta and Arizona versus Youngblood, which we've heard a lot about. So they're going to try to use the Trombetta to clear up their side. Under Trombetta 467 U.S. at 488, due process is violated when the defendant shows that the state lost evidence before trial that might be expected to play a significant role in the suspect's defense. To meet this standard, the evidence must, quote, possess an exculpatory value that was apparent before the evidence was destroyed and be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means, unquote. ID at 489. Evidence does not have apparent exculpatory value if it would have provided, quote, simply an avenue of investigation that might have led in any number of directions, quote unquote. Eubanks versus Frank 392, and that was in 2004. Under Youngblood 488 U.S. at 57-58, the defendant establishes a due process violation if he shows that, number one, the state lost or destroyed evidence that is potentially exculpatory, and number two, the evidence was lost or destroyed in bad faith. Let's stop there for a minute. Under Youngblood, the defendant establishes a due process violation if he shows the state lost or destroyed evidence that is potentially exculpatory. Green check mark, yes. The pelvic bones would have definitely been potentially exculpatory evidence. And number two, the evidence was lost or destroyed in bad faith. Excuse me, the people that wrote the law that we need to retain biological evidence also agreed to retain biological evidence in the sense that unless they're breaking the law, they still have all the pelvic bones. So when you break a law that you're well aware of, that's called bad faith. Okay, let's continue. There is a well-developed body of Wisconsin case law that follows and applies Trombetta and Youngblood when addressing whether the state's loss or destruction of evidence before trial violates a defendant's due process rights. To put it, sucks. I can't even say that. Sucks. You guys are going to have to help me out. I need to go to lawyer school here. Sucks. I can't even say it. I literally can't. Subsequently. It doesn't have a B in it. Shouldn't be subsequently. I'm going to use subsequently because that's what I think it should. To put it subsequently, no, they're using the right word. I just don't know it. A defendant's due process rights are violated in the police if the police, one, fail to preserve the evidence that is apparently exculpatory, or two, act in bad faith by failing to preserve an evidence which is potentially exculpatory. State versus Huguet. Again, A, defendant's due process rights are violated if police fail to preserve the evidence that is apparently exculpatory. Green check mark. Two, act in bad faith by failing to preserve evidence which is potentially exculpatory. They're hanging themselves. Wow. The first step in the analysis is whether the bone fragments at issue recovered at the Randick quarry constitute exculpatory evidence. The bone fragments are not apparently or potentially exculpatory in any way. One up, Gretchy? You got to quit getting down. Yeah, stay. The Trombetta limits any due process claim involving the state's failure to preserve evidence to constitutionally material evidence. Evidence which both possesses an exculpatory value that is apparent before the evidence was destroyed, and where no comparable evidence is available to the defendant by other means. Trombetta 467 U.S. at 488-89 regarding the Trombetta standard, Avery has not established how these bone fragments are anything other than an avenue of investigation that might, let's change that word. Rubber Ducky wants to put in potentially. See, might, potentially, that's all we need to establish. Might lead in a number of directions. Avery has failed to show in his pleadings how the existence of assuming argudo that testing would have determined the fragments in number 8675 were human. Human bone fragments found in the quarry a half a mile away support any of his arguments that individual A or Scott Blodorn and or Ryan Hilligas or Bobby Dassey or Scott Tadage are the real killers. Woo! Wow. They're claiming that the bone fragments do not they're not Possibly. Yeah. Wow, that is a strong statement, you guys. Avery has failed to show in his pleadings how the evidence or the existence, I'm sorry, the existence of human bone fragments found in the quarry a half-mile away support any of his arguments that Scott Blodorn, Ryan, Bobby, or Scott Tadich are the real killers. We don't have to establish that, you guys. We don't have to establish that at all. We simply need to show that Avery could not have possibly done this. And the state has established that he had to have done it at his trailer home right there in his yard. So that's absolutely throwing us down a distractive line of thinking. We do not need to establish that Scott Blodorn, Ryan, Bobby, or Scott Tadich are the real killers. We simply need to show that these bone fragments that are human, or they wouldn't have been given back to the hall box, could potentially be the victims. And if so, it takes our guy, Steve Avery, and Brendan Dassey off the table as a suspect. So this is total smoke and mirrors. Ugh. Over the course of the past 2.5 years, since the filing of the original motion for post conviction scientific testing on August 26, 2016, Avery has changed his theory of who the real murderer is at least 3 times. Initially, the focus was on an individual A and individual B, later determined to be Scott Blodorn. And then the focus shifted to Ryan Hilligus and Avery's June 7, 2016 post conviction motion. In that motion, Avery claimed the only person who meets the Denny's test was Ryan Hilligus. Shortly thereafter, in the summer and fall of 2017, Avery turned his attention to Bobby Dassey and Scott Tadich. Since that time, Avery claimed Bobby Dassey and I'm sorry, Avery claims Bobby Dassey and Tadich are the real killers and presumably meet the legitimate tendency test. As this court is aware from prior filings, Bobby Dassey and Scott Tadich, along with Blodorn and Hilligus, were included in trial counsel's original third-party liability motion as viable suspects. Court the trial court found the evidence lacking in pretrial. Presumably, Dassey Tadich remains his picks. The state will address Avery's pleading deficiencies in this context. Okay, you guys, what he's referring to is a document that we're going to have to talk about in a separate video, and it is the third party suppression of evidence motion. So what it was is it was saying that you can't use this evidence because it isn't all on me. It's also on these other third party individuals where he named Scott Tadich, all the Dassey boys. He even named his brothers, and any of the people that went to the salvage yard is what they're referring to. And that was where he did not provide a motive for those individuals at that time. And the reason he didn't is because Avery himself, Steven Avery, did not have a motive to kill Teresa, and yet he was brought up on trial. And so Stephen Avery felt, and I feel that this is very inadequate, ineffectual counseling on Mr. Buting and Strain's part, that they did not explain to him in a clear method that he had to check all 3 boxes of the Denny requirements. And the third box was that the people had to have a motive. There were motives. So Bobby Dassey was sitting on that computer according to the timestamps, him being the only one home, while the dark web is being searched about dismemberment of bodies and all this kind of stuff right before the victim arrived. And we all know that that kind of thinking, that depraved mind thinking, is a motive in itself. That's why there's such things as serial killers. So let's continue on. I hope that helps. For those of you that are a little bit more confused, do know that we're going to break down sections of this, and we will be going over this over the next week on a daily time frame. Um, We'll take a time, we'll break down each section so that we can bring up documents and actually combat and answer to each part of this. But today we're just going to go through this and do the best that we can. The CDs were absolutely suppressed and not brought out at trial, which would the star witness that the only one that saw Teresa allegedly walking towards Steve Avery's home, the trailer, was Bobby Dassey. And guess what? Bobby Dassey has CDs. I believe there's 7 CDs that are completely depraved, sick-minded web searches in the dark web of dismemberment of bodies, of child pornography, of indecent, very demented searches. And the state hid this information, put a little striped shirt on this kid, threw him up on the stand, and let him sound like he has no reason to lie at all. And he has an alibi, which we now know Scott Tadich never went to see his mom in the hospital. So he lied. And once you lie and you perjure yourself, where do you draw the line that you don't lie? So did he really see Bobby on this road 147? All right, off the soapbox. Let's go back. We'll get into this really deep. In this most recent filing, Avery spends considerable effort telling the court what his 3 experts, Doctors Dehane, Symes, and Selden, think about the bone fragments. But nowhere in that discussion or anywhere else in the motion is there a discussion of how the assumed, but not proven, human bone fragments found in the Randick quarry advance the theory that anyone other than Avery was the killer. Avery's materiality discussion, which is a post conviction relief motion from March 11, 2019, misses the mark. Maternally related to guilt or innocence and is determined by the facts in a given case and their interrelationship to other facts and evidence. Materiality has nothing to do with Wisconsin Statute 968.205 and 974.07. In U.S. v. Bagley 473 U.S. 667, 1985, the court defined materiality further and refined the Brady rule, holding that regardless of the type of request, favorable evidence is material and constitutional error results from its suppression by the government. If there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. ID at 682. Emphasis added. A reasonable probability of a different outcome is shown when the suppression of the evidence undermines the outcome. The bone fragments were not apparently exculpatory. Oh, lordy. So what they're trying to say, you guys, is that if the jury had known that the pelvic bones in the quarry were Teresa Halbach's, they still would have said he's guilty. Now, how would he have got down there if he's busy up there killing her up there? See, the thing is the evidence establishes that the post that oh, the prosecution established Steve Avery's evidence around his home. That's where they told the jury she was killed, that's where the evidence said she was killed. And because the evidence said she was killed and maimed and murdered and dismembered there at his home, and he was at his home, is why the jury decided he was guilty. Now let's take one of those factors out. How would the jury still come to the same conclusion if the state's proved that Stephen was at his home the whole time? How did he get down to the quarry to do this? He cannot be in 2 places at once. And let's bump this up a notch. It's no longer just Steve Avery in his home with his nephew, Brendan Dassey. It's now anybody that's down in that quarry has access to this girl. How do we know? I mean, let's throw some tinfoil hats on here, kids, but I'm going to go out there on a limb and say, how do we know that somebody on an inloader down there didn't just flat out run her over with the end loader and pile of dirt on her. Okay? We have motive. We have the motive that we have Stephen Avery coming back into this property trying to take over as the firstborn. He's going to gain the inheritance of the property. So we have the king's son going to be going over and getting the crown, and we have people that have been working this property for 18 years without his help. Do you think there may have been a motive there? Do you think that maybe the dark web might have inspired a young fella to take some action on a young girl that is very similar in images to what he's looking at on a computer? I mean, why is everybody so afraid to give up their DNA in this case, if there isn't a problem? Once you're a liar, you're always a liar. That's right, Zully. That's right. Hey, misunderstood. We're gonna go through this. Keep going here, but you can always rewind. This will be posted. And here we go. It is also worth pointing out that in comparing the evidence ledger sheets with Deputy Hawkins' report from the evidence, or I'm sorry, from the events of September 20th, 2011, there are many fragments from the quarry that may or may not be human, still in evidence available for testing. Thus, Avery has failed to establish that he cannot obtain comparable evidence for testing. Oh my golly, BS, BS, my BS alert's going off. We've clearly established that it is the pelvic bone that we need. There is not a pelvic bone in the evidence currently. We need the pelvic bone. This is the only bone that we can for sure say, because they commingled them in a box, the pelvic bone's the only one recognizable that we can pull out of a commingled box and say, yep, this was at the quarry. The rest of the bones have been shuffleboarded. Okay. Hey, family, been missing ya. Hi, Jay O'Shea. Good to see you. Yeah, what evidence, Tyne? Yeah. Regarding the Youngblood standard, the bone fragments were not potentially exculpatory. Further refinement of the Brady rule in the potential, or I'm sorry, rule in the pretrial setting occurred in Youngblood. There, the court determined that the good faith or bad faith of the state mattered when the failure to preserve evidence, quote, of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant, unquote. The court held that a criminal defendant must show bad faith on the part of the state when the state fails to preserve potentially useful evidence. ID 58. Emphasis added. Absent such as showing, there is no due process violation. Oh, my teeth are going to break when I grit them. The potential usefulness of the evidence found in the quarry is debatable. To who? Oh, okay. While trial counsel made use of the state's inability to discern whether the fragments property tag 8675 recovered from the quarry were human, and in closing arguments, trial day 23, Avery fails to show how the definitive determination the fragments were human immaterial in his most recent theory that Bobby Dassey and Scott Tadich are the real perpetrators. Avery fails to establish how a definitive determination would establish a reasonable probability of a different outcome. Right here, recovered from the quarry were human. How do we discern that? You gave them back to the family as their daughter. Was Teresa Halbach human? I'm typing to you guys because I want this left here. I'm just putting it in safe. There you go. All right. What I typed was Teresa Halbach human because they gave back her bones to the family? This is simply insane. Okay. Where were we? Here we are. There is no discussion of how and when these assumed human fragments were planted in Avery's burn pit. There are no facts supporting when, where, and how Teresa Halbach was killed or burned in the barrel other than the speculative assertions of Avery's experts. There is no discussion other than the experts. Okay, what are they wanting? We've submitted what the experts said. That exactly is what you need. This is so much smoke and mirrors. This is the weakest thing I've ever heard. So, other than the experts giving their opinion, what are you talking about? Okay, there is no discussion how these assumed human bone fragments from the Randick quarry constitutes evidence that satisfies the legitimate tendency test, such that there is any viable third party suspect under the rules of State versus Denny. State versus Wilson. There is no analysis of how these non human, or, oh, I'm sorry. There is no analysis of how these now human fragments establish motive, opportunity, or a direct connection to the crime. Moreover, there's no analysis demonstrating why it's not possible that Avery himself placed the bones in the quarry to divert attention from himself and escape detection. After all, bone fragments belonging to Teresa Halbach were found in the Dassey burn barrel. Avery fails to tell us how a possible third location of Halbach's remains possesses any exculpatory value. Furthermore, the state did not act in bad faith when it released the bone fragments to the Halbach family. Really? Disposition of some of the bone fragments occurred on September 20, 2011. The Court of Appeals has issued a decision denying Avery's request for new trial on August 24th, 2011. In analyzing the circumstances surrounding the disposition of some of the fragments for burial, it is important to note that the bone fragments, human or not, were not part of Avery's direct appeal. State versus Avery 2011. There were no pretrial requests made by trial counsel, and there were no requests by appellate counsel during direct appeal to examine any of the bone fragments. The fragments had nothing to do with the issues raised at Avery's direct appeal. As addressed below, the state preserved some of the bone fragments clearly identified as the remains of Teresa Halbach, and that could be identified as a female human bone. The state made reasonable efforts to determine the identity, hence important, of the bone fragments in property tag 8675 when it sent the items to the FBI. The FBI could not test the items. When the items were inexplicably released to the family, their origin remained scientifically undetermined. Under the circumstance, there is no bad faith. The mere assertion of a claim of manifested injustice, in this case, the alleged destruction of the evidence, ostensibly resulting from the return of some fragments for burial, does not entitle Avery the requested relief. State versus Allen, 2004, Wisconsin. Moreover, Avery cannot simply rely on the affidavits of trial counsel of his experts, for that matter, to carry the day. Lord. In order to secure a hearing on a post conviction motion, a defendant must provide sufficient material facts, e.g., who, what, where, when, why, and how, that, if true, would entitle him to the relief he seeks. A material fact is a fact that is significant or essential to the issue or matter at hand. A defendant must allege sufficient material facts within the four corners of the post-conviction motion itself. Avery has failed to meet his burden if he has failed to allege sufficient facts that establish either trombetta or young blood violation, that the motion should be denied. Okay, you guys, the school bus is here. My dogs are going to go nuts. The kids are going to come in. It's going to get really loud. So I'm going to go ahead and read until I see the kids come up to the door, the dogs start, and then I'm going to jump onto the chat with you guys for just a moment, give kids heads up because they did not obviously know the state was going to reply and that mom is on alive. So I can see them now. We'll go ahead and read the title. Number 4, Avery cannot raise a statutory claim in Wisconsin statute. And with that, the fam's home. So we'll go on pause. We'll take a 2-minute, 3-minute break here, and I will be back. Okay, guys, I'm back. One of my children is at a track meet. I forgot and didn't get off the bus, of course. And I was like, "Where's your brother?" So anyway, we're all good now. Just had to get some people to call the school and find out where my son was. I forgot today was his first track. So spring is here. All right, guys, where are we here? Number 4. Before we jump in, let's just see what's going on. Tyne says, "I truly think KZ was expecting a weak reply like this really is. I don't see it holds any water in a real court, but Suckowitz," she wrote Sucka this, "probably has a way around it, so it will likely end up in COA again." Court of Appeals, yeah. When somebody says Court of Appeals, I'm sorry, when they say COA, they're meaning Court of Appeals. Let me go ahead and put the airplane, there we go. Put the phone on airplane mode so it's not dinging while we're trying to read. Jeannie says another thing, they didn't let the coroner do her job. They got someone else to do it. Why? That's a great question, and we can get into that at another time. Jeannie says, I agree. Patterson would have solved it by now. Put it straight. Wish it were that simple. Dee says, charge the officials that were involved, whom were not to be involved, or the state's attorney for tainting the jury. Also, one of the jurors was a volunteer employee of the sheriff's department. That is actually very true. All right, guys, we're going to jump back in. Let's see, we're on page 14. So if you're just joining us, you can go to we had a little intermission there. Oh, you can go to the Rubber Ducky Steven Avery Files.com. And there you can see here that you can choose. Oh, let's see. How did we do this? We went do evidence RD Avery Library. We click that. We scroll down. We've got post conviction. Click that, and the document is here. It's labeled 2005 CF 000381. All right. Avery cannot raise a statutory claim in a Wisconsin Statute 974.06 motion, but regardless, the state did not violate Wisconsin Statute 968.205 subsection 2. Avery asserts the state violated Wisconsin Statute 968.205 when it returned bone fragments recovered during the investigation to the Halbach family for burial in 2011. Avery is wrong. The state complied with the directives of Wisconsin Statute 968.205, subsection 2. So, Wisconsin statute is, let me make it a little bigger so I can read that part. Except as provided in subsection 3, if physical evidence that is in the possession of law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, delinquency adjunction, or commitment under 97117 or 980.06, and the biological material is from a victim of the offense that was subject of the criminal investigation or may reasonably be used to incriminate or exculpate any person for the offense. The law enforcement agency shall preserve the physical evidence until every person in custody as a result of conviction, objection, or commitment has reached his or her discharge date. Emphasis added. First, okay, do they ever have a second or they just keep bringing up first, you guys? First, the state preserved representative samples of the bone fragments that were clearly identified as being female human bone fragments. The state also preserved crime lab item BZ property tag 9626. The thigh bone fragment collected from the Avery burn pit with attached human tissue from which mitochondrial DNA testing identified the bone fragment and the tissue belonged to Teresa Halbach. In addition, property tag number 9597, two tubs of cranial fragments. Tubs? Okay. The occipital and the parietal bones. Silkman or Tony would he would be able to say these words for you a lot better than I do, showing the high velocity bullet impact and lead spray. Property tag number 9598, cranial fragments identified as facial pieces are not among these items returned to the hallback. See Eisenberg report. Exhibits number 1, 5 through 7. Hawkins report, exhibit number 2, Calumet County evidence ledger sheets. Moreover, Wisconsin Statute 968.205, subsection 2, should not be interpreted as a mandate to preserve every single piece of biological evidence recovered during an investigation. That would place an unreasonable, if not impossible, burden upon law enforcement. Imagine a crime scene where there are hundreds of blood droplets spread throughout a multi room crime scene. To mandate law enforcement officers preserve samples of every droplet of blood would be wholly unreasonable and burdensome. This is especially true in cases where someone has been convicted of first degree intentional homicide and receives a life sentence. It would be unreasonable to insist that the law enforcement maintained every single one of those samples throughout the entirety of the prison sentence up until death. Similarly, after autopsy, medical examiners and law enforcement officers routinely release bodies for burial, notwithstanding a homicide prosecution is soon to follow. In Youngblood 488 U.S. 51, the court recognizes the unreasonableness of preserving every bit of evidence that might have some value down the road at trial when it is observed. We think the due process clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said than it could have been subjected to tests, the results of which might have exonerated the defendant. Part of the reason for the difference in the treatment is found in the observation made by the court in Trombetta. Internal citation admitted that whenever potential exculpatory evidence is permanently lost, court faces the treacherous task of divining the import of materials whose contents are unknown and very often disputed. Part of it stems from our unwillingness to read the fundamental fairness requirements of the Due Process Clause. See Lisbon versus California, as imposing on the police an undifferentiated and absolute duty to retain and to preserve all material that might be of conceivable evidentiary significance in a particular prosecution. I want to stop there for a minute. Okay, they took a crime scene with all these drops of blood and da 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 da. Here's the thing, whatever evidence that they collect, now, if they don't collect all the blood evidence, they don't need to retain it all. So it's not impossible. But if they collect biological evidence and that evidence, the samples, the recordings of those, as well as the blood drops themselves for testing later, are the main evidence that criminally puts this person behind bars, that needs to be retained the entire lifetime they are in. Young Blood at 57 58, 1988, emphasis added. Next, Wisconsin Statute 968.205, subsection 2 requires that biological evidence be preserved in two situations. Number one, if the biological evidence is identified as belonging to the victim. Um, yeah, that's why you just gave it to the family because you're saying that they are the victim's bones. Or two, it may reasonably be used to incriminate or exculpate any person for the offense. Neither of these conditions exist with respect to the bone fragments recovered from various locations in the quarry. First, here we go again with first. None of the bone fragments recovered from locations in the quarry were positively identified as human, let alone the remains of Teresa Halbach. A few of the bone fragments, property tag 8675, were given the designation of possibly or suspected human. Report of Dr. Eisenberg, exhibit number 1, 6, and Eisenberg testimony in the trial transcript, day 14. In late 2006, early 2007, prior to trial, the state attempted to have the fragments contained in property tag 8675 further identified. Arrangements were made with FBI Special Agent Mullen to transport the items to the FBI laboratory in Quantico, Virginia. The FBI examined the fragments and reported that the samples were too degraded to be further analyzed. I'm going to grab a drink. Exhibit number four. Thus, no determination can be made as to whether they were human, and more importantly, for this statutory analysis, whether they were the remains of Teresa Halbach. Wisconsin Statute 968.205, subsection 2, does not mandate the preservation of suspected, unknown, and undetermined biological evidence, just the biological material from Teresa Halbach. Therefore, the state was under no obligation to preserve those bone fragments. Okay, um, when they're giving the bones to the Halbachs, and saying, here are your daughter, here's your daughter, that in itself is claiming the remains are Teresa Halbach's. And any bone material that is possibly human, even if they're not going to spend 20 seconds during trial, is relative to the incarceration of both Brendan Dassey and Steven Avery. Second, we'll go back into this. Second, Avery argues, pursuant to Youngblood 48 or 488 U.S. 51, that the bone fragments were either apparently or potentially exculpatory. As addressed above, they were not. Moreover, analyzing a claim that the fragments constituted evidence that the state had a statutory obligation to preserve its controlled is controlled by Wisconsin Statute 968.205 subsection 2, not Youngblood. Pursuant to the statutory text, the test is not whether the evidence was apparently or even potentially exculpatory. The test is whether the evidence may reasonably be used to incriminate or exculpate any person for the offense. And in this case, we're saying yes, it would. The test is not whether the evidence possesses some incriminating or exculpatory value. The test is whether the evidence itself could reasonably incriminate or exculpate a person for the offense. Here, it would not. The evidence alone, if tested, would not prove Avery innocent or guilty, nor anyone else. The state did not violate Wisconsin Statute 968.205, subsection 2, when it released some of the bone fragments to the family for burial. Hey, Millbilly, good to see you. Millbilly has been doing some fantastic work lately. So if you get a chance, jump on his YouTube channel. I stand up with him in this fight against the injustice because, boy, we've got some seriously wrong convicted fellas here with Brendan Dassey and Stephen Avery, and that's what we're working on. So shout out to Millbilly, thumbs up. Great job, guys. Great job. Um, Let's take a second before we jump into this huge section, the Andy rapid DNA identification technology. Let's recap just a little bit. So they're saying they don't want Judge Sakawati to recuse herself because apparently they don't consider it to be a problem because she wasn't acting as a judge. She was just, being Angie at the meeting. But you know what? You don't take your judge hat off, it stays in place. So, yeah, you have your hand basically in the jar, and that's a conflict of interest. So, by all means, I encourage you to recuse yourself, so that you can honestly, somebody can call you honorable, because at this point, I'm not seeing it personally from my standpoint. The next thing that they're saying is that these bones that they gave away, it's not breaking the law because you don't have to retain every blood drop. Well, no, you don't, because if you don't collect the blood drops, they're not considered evidence. They're simply missed chances, missed opportunities. So, yes, if you do collect evidence, you need to maintain it. And they may be releasing that body to be buried. Um, but have there been exhumed bodies for evidence? Absolutely. And what are we asking? Well, if those bones are buried, time to get your shovels out. No offense, but we need to get this figured out. If you truly want justice for this victim that has been murdered, then you will understand that with not knowing if the state's saying they don't even know if they gave them human bones or not, we definitely need to exhume this body, these bones, not this body, but these bones. We need to test this pelvic bone to see who really killed this woman. We need to bring the proper killer to justice. How many other people has this killer killed? Did So it was just a one-time deal, the state thinks that, we have this one guy did it, but yet there's many, many, many deaths that look just like her in the area from years to follow. Isn't that interesting? That the first time when Stephen Avery was convicted wrongfully of the assault and attempted murder of Penny Bernstein, that the rapist was allowed to continue to harm women and be a menace to society. And here we go again. How can the state itself sleep at night? There is a petition. Thank you, Trixie. There is a petition being rounded about, and you'll see it on Twitter. I'm sure you see it on Instagram, Facebook, and all the major media sources that is asking you to sign the petition to recuse Judge Sukowitz. Just, you know what? Humor us, sign it, please. She needs out of this. She needs out of this, even if she just saves her own face, just to retain the honorable status that I don't feel she deserves. Okay, guys, we're going to go into the fifth part. Let's grab a drink. Okay, Andy, rapid DNA identification technology is not authorized or approved for forensic use. The technology should not be used on forensic sampling. The Federal Rapid DNA Act of 2017 authorized rapid DNA technology to be used in police booking stations to help identify suspects in the same way a fingerprint is used or currently used. Congress recognized that rapid DNA technology allows for check buccal swabs to be obtained and placed in a cartridge that slides into the rapid DNA machine, which then reports back a DNA profile. Although the defendant currently states that rapid DNA analysis is allowed for testing buccal swabs, he fails to mention that it is only the testing of buccal swabs that is approved for the lawmakers. The Federal Rapid DNA Act of 2017 specifically stated that at present, rapid DNA technology can only be used for identification purposes, not crime scene analysis. What are we wanting to do, guys? What are we wanting to do? We're wanting to identify, right? So, identification purposes. Great. We're not out on the crime scene, out in the dirt, trying to analyze, whether this dirt is dirt. We're trying to identify the identification of a victim. This is not just, this is not the murder weapon we're trying to test the blood on. We're actually trying to identify a human being's bones. Let's go on to say the technology is not approved for testing the samples the defendant wants to test. I disagree strongly. It actually states right there that it can only be used for identification purposes, and that is what we are asking to do, is to identify the bones as to if they are the victims. Importantly, Congress specifically, sorry about my mic, it just hit my face. Importantly, Congress specifically designated the director of the Federal Bureau of Investigation, FBI, be responsible for issuing standards and procedures for the use of rapid DNA instruments and resulting DNA analysis. The FBI subsequently determined that cheek swabs are ideal for rapid DNA machines, and they also contain large amounts of fresh DNA from one individual. The FBI further observed that forensic samples vary widely from the age, exposure, and nature of the sample of the amount and quantity of DNA it may contain. The procedures developed by FBI concerning rapid DNA analysis have been endorsed by the Scientific Working Group on DNA Analysis Method, SWGDAM. SWGDAM is a group of scientists representing federal, state, and local forensics DNA laboratories in the United States and Canada. On October 23rd, 2017, SWGDM issued a position statement on rapid DNA analysis and stated currently available rapid DNA instruments were specifically developed for reference sample buccal swabs taken from persons during the booking process. This is because they contain high quality single source DNA, which makes them ideal. the rapid DNA application. However, SWGDM determined that rapid DNA technology is not currently suited for crime scene samples. Similarly, the American Society of Crime Lab Directors, the ASCLD, a group that represents managers, directors, and leaders of crime laboratories across the United States, spanning the entire range of local, state, and federal government laboratories, as well as private labs, issued a position statement on November 15, 2017, determining that rapid DNA is not approved for use on forensic evidence samples, but is approved for the use with single source known reference samples buccal swabs. Finally, the National District Attorneys Association NDAA issued a position statement on the use of rapid DNA technology on January 30th, 2018. The NDAA supported the implementation of rapid DNA instruments in booking stations utilizing single source arrestee samples. However, NDAA does not support the use of rapid DNA technology for crime scene DNA samples unless the samples are analyzed by experienced DNA analysis using the technology working in an accredited forensic DNA laboratory. Let's do that. Did you catch that? You guys, right there. However, NDAA does not support the use of rapid DNA technology for crime scene DNA samples. The key word, unless the samples are analyzed by experienced DNA analysis using that technology working in an accredited forensic DNA laboratory. Dr. Selden is willing to do the testing in an accredited forensic DNA laboratory. So the state itself has just wiped out everything they set up to this point because we absolutely have an experienced DNA. The one, the one guy. Oh, Gretch, do you really need up in the chair now? Come on, let's do this. Are you going to come? Okay, let's do this. Mama, help you. Oh, getting too big. So there you go. Everything they set up to this point on the DNA testing does not matter because there's a however. So let's continue on. Simply stated, rapid DNA analysis is not approved for crime scene sample analysis. The experts in the field have determined that rapid DNA testing is not ready for crime scenes. There's a huge difference between fresh buccal swabs and a 14-year-old charred and calcined bone fragments. Therefore, the testing proposed by the defendant cannot be done reliably, if at all, and therefore should not be done. Conclusion. Oh, Lordy, you guys. Defendant's motion for reversal and new trial cannot be brought in a Wisconsin statute 974.06 motion. The state did not violate Wisconsin statute 968.205. Defendant's motion for new trial is replete and conclusory allegations and unsupported hypothesis, and the motion is deficiently pled. Lastly, the forensic testing contemplated in defendant's motion is not authorized or approved by the relevant forensic community. Therefore, the motion must be denied. Dated this 29th day of March 2019, respectively submitted by your Attorney General Joshua Call, who is the son of Peg Lockenslager, who was our attorney general that has been fighting Steven Avery from day one, who had denied his 1985 case. So, Joshua, I'm sorry, but I think you have a conflict of interest as our attorney general of the state of Wisconsin to be in this case because you are the son of the woman that has been fighting this case from day one. And I believe you yourself should recuse yourself and take your judge, suck you what's, whatever, suck a what's. I can't say her name. I'm not going to try with her. Take it all because you are related directly to Peg Lockenslacker. She was the attorney general that sat down with Stephen Avery and said in 1985 that they had done no wrongdoing. And we know that wasn't true because Stephen Avery was absolutely on the track to receiving a large sum of money. Even if it was settled out of court, we're looking at $4.5 million most likely. What could he have done with that? What was on the board for Steve Avery at that time? A large sum of money. He was wanting to get out and buy that, not wait for his inheritance, just outright buy the yard there. So that would have pulled the salvage yard right out from under a lot of family members that had done the work. Do you think they might have had some sore spots about that? When you go ahead and look through the archives, we have newspapers in the library, and there's an article in there. We can do a show on it sometime where Stephen Avery says that Chucky told him, quote unquote, if you can't if you can't if you made it in that prison, you'll be able to make it out here. You got to be able to make it out here. What's your problem? Well, he was facing all kinds of problems. He said his place was being watched. No doubt he was. It sounds like Steve Avery's got a lot of made up things, but when you look at it, it's all true. He states a statement and it sticks. It's still there. Who else in this case can you say that when they made their statements are the same without choice, without any change? Angie Suckowith? So do you guys have anything you want to talk about? This is the end of the motion. This is simply just their response. Both sides are being heard. This is the prosecution's, and this is what it feels like. You knew they were going to come back and try to back it all. They really don't have a leg to stand on. Everything they're saying, Zellner has covered, and she's done a fantastic job on. Um, I really feel like they're just they're throwing up things and they're hiding the words unless and things that just they give themselves away in the statement. They make a 30-minute statement of why it won't work, and at the very bottom of it they write, for just like Kratz would do, about 2 seconds about unless you have an expert that can test it in a real lab. Yeah, we got that. So the DNA evidence stands. Yay! What's next? Waiting game. Absolutely. Now we wait for Genius ask. Now what is next? Waiting game. Yes. What that is the appellate court has all the time in the world to respond. We are not on a timeline for them. They will review this. Hopefully, we don't get an immediate response. We want them to chew on this. We want them to look over and really decide this. Now, keep in mind, it's not just DNA testing, it's not just suppressed evidence, it's also the lack of having hearings. Steve Avery has been muted from 2007 on. He has not got to speak in a hearing yet. We're simply asking for fairness. And again, the exception to the law, right through the middle of this entire motion for a retrial, was that they based the state just got done basing their entire shield, their entire statement on a couple things. One, that he got a fair trial. No, he did not get a fair trial under you can't suppress evidence that would have undermined the verdict of the jury and call that a fair trial. You can't have a fair trial when you have conflict of interest, because conflict of interest, they're actually on the jury. We have volunteers that work at the department that is being sued in a civil suit. If your employer is being sued by company A, you cannot go to company A and service them on something else and be thought that you're going to do it in good faith, because naturally it predisposes you to having a motive for a self-serving reason, a self-serving outcome. So, like I said, even our attorney general is the son of the previous attorney general, and he waited to divulge that till after he's elected. How convenient. How convenient. And what does he do? Right away, he starts checking into our state crime labs. Oh, yeah. Our state crime lab in 2006 was undergoing the exact same time that they have Steve Avery and Teresa Halbach's evidence being processed. Our Wisconsin state crime lab is under investigation with sightings that they have actually falsified fingerprints incriminating someone, and falsifying tests that they said they did that they didn't do in an unrelated case. Let me tell you, you want to talk about blood in the RAV? How hard was it if we have people that are working at this lab that are saying that they did fingerprint test matches that they didn't do? I mean, that's a fact. They didn't do them. They lied. A DNA forensic tech lied, said they did them. She said, "Oh yeah, I did those. I did those." No, you didn't. And now somebody was criminally processed because of that. Now think of that mindset and think of that RAV 4 sitting in the crime lab 3, 4 feet away from Stevens Grand Dam that we all know is covered in blood. Is that a little distilled water in a buccal swab and then rubbed 3 feet away in a few places over there? You just rehydrate the blood with some sterile saline and just drip, drip, do a little decoration there, finger, with your little buccal swab. And it's as simple as that. And now we've got the RAV. We can test the RAV. And guess what? Poof, magic, smoke and mirrors. We have Stephen's DNA removed from the Grand Dam. And now, da da, it's right here in the RAV. Yay, we've got him. Oh, yeah. So we're going to be doing, I keep saying we're going to be doing a state crime lab video, but honestly, every time I get on it, I get so hot. I can't stand it because there's the answers all laying right there. They didn't need to worry about what the evidence was going to say because they had the boss saying, put her in the garage, put her in the trailer. Absolutely. So let's go ahead. Let's check in. We'll see where everybody is. And then we're going to wrap this up. I do want to talk just a moment before we go. Let's see. Angie Rolfe says, just the fact about the crooked juror should be enough. This is ridiculous. I agree. I agree. Um, Crockett says, think Angie had 90 days with a possible 90 more. Can someone confirm? Hmm. We'll have to do some checking on that. I'm not sure. Um, how convenient for them? Baloney. Yeah. A lot of support here for the channel. Thank you guys. Thank you guys. Wonderful. Roll says it is a match between KZ and Angie. Who will be faster, KZ with a reply or Angie with a denial? Hmm. Well, now it's up to the appellate court. So neither one of them have a chance to answer. Unfortunately, Zellner has to wait, and so do we. This is going to be a long wait. So in the meantime, we've been talking for a while on each of these videos that we are making a remaking a murderer video for you guys. It will be a long series. The joke running now with the researchers is it started off, ma'am, in 20 minutes, and we're looking at 2 hours. So we may have to break this up into like a 6-part series, I think. But it will be well worth it. It is astonishing to see this remaking a murderer. It takes the past and the present, it commingles them just as this case is, and it presents both sides of the coin. But in that, you can honestly see the flow of events is very clear. We've also, what's slowing us down on this is to provide you guys with some excellent references so that a PDF will be produced that you'll be able to open up and click the links yourself to go read the legal document. So, this is a huge step forward to making sure that our credentials and our credibility is 100% guaranteed. And we do appreciate all the fact that you guys stick with us through everything. Much love to every one of you. So, with that, um, I want to thank each of you for staying tuned on a very, very long winded read. I did jump on my soapbox more than normal because I couldn't help it. This was the first time I read it as well, and it spikes a lot of passion in here. I'm very frustrated with the case, as you all know, and that's why we continue to bring public awareness. We want to spread the news, so please do share this so that other people that may be at work, don't have time to jump on the computer and read the documents, have the opportunity to go through it with us. We want to keep everybody in the loop of what's going on. So, okay, guys. Oh, Jeannie asked any news on the mystery photo. Oh, great. Thank you, Jeannie. Thank you. Thank you. Yes. Okay. So referring back to the last video before we go, let's go ahead and check out that last video. It was the smoldering barrels. We do have information. We have great updates, and you'll be extremely pleased to know it is absolutely not photoshopped. We have confirmation that it is appearing in the MAM documentary, and we have one of the RD researchers is contacting the producers of Netflix because we have been informed a rumor, and that's all it is. There's nothing to substantiate the claim, but that the producers themselves were allowed to stage this smoking barrel. Usually, when somebody is doing a true documentary of this nature, they will put a disclaimer that states it's a reenactment when they do something like that. So, we do have very, very significant questions with that. However, we're not on board that this is a 100% legitimate smoking barrel either. So, we're waiting to find out. As far as the big metal box that looked like a hot box, as we recall. That we have had wonderful armchair sleuths came up from everywhere explaining to us. For those of us that are not in the air conditioning unit system repair, we did not know this, but that appears to be, and we've had hundreds of people agree to this, that this is a unit used for transferring air in a mobile home or in a trailer of some sort. It could even be a refrigerated trailer. And that's why you see this fan work that we were talking about and the exhaust uh, pipe that comes off. So we were close, but hey, good good thinking on our part. As far as why do we see a blurry snowmobile in the back? Apparently, this was not just a photograph. It's actually in MAM. It's a short video. So what we think has occurred in looking at this, we do know it's not photoshopped 100%. So we've got that out of the way. We're simply trying to get to the origins of the photo. So if the origins of the photo is taken from a video that's moving, you can see then where you might get a little bit of distorted view on that back part where that snowmobile was. So that's some of that. It does appear that this picture that we took, that well, we didn't take it, but that was given to us, this picture that we took out of the library, out of the anonymous box, it seems to have, we've been able to match it, if you will, to the video on MAM. And I want to see, someone said that it was MAM 1, season 3. Don't quote me, but there's a start. So we are still working on that. We are applying to find out where it originated from. Did the producers get this video given to them through Fairness of Information Act? Were they on the were they actually able to set this up? So we're not a lot further, but we do know it's not Photoshop, so we can quit worrying about debunking everything in it. It's legitimately there. And I knew that in the sense of that little piece of cement that takes that 109-degree turn to the bottom of that one barrel. That would be strange for them to Photoshop it flipped. So I was suspicious that it couldn't be Photoshopped, but I wasn't sure. We've got some weird, strange people that'll just make up evidence, throw it out there, call it evidence. But the truth is that this individual, um, that originally clipped this picture has come forward. What they were doing is they were basically asking the same thing we were at the time. And then this picture got sucked into the media. And back in the day, people said they debunked it because they said it was the producer staging the event. But we have yet to have anything to back that up. So we have contacted the producers in hopes to be able to do that. No, I don't want to do that. Okay, guys. Is there anything else we want to? Oh, thank you guys so much. Um, is there anything else we want to discuss? Let's just make sure we're not missing something. Hi, Emma from Ireland. That's great. Thank you. I just appreciate everybody from all over the world joining in. Okay, roll helps us. It's Ma'am 1, episodes 3, and it's at 33.45 for minutes. It's done after the cops were gone, in my opinion. Yep, could be, Roll. You may be right. But at the same time, we need to validate that because we have had that in the past where we bring up a piece of evidence, and such as we brought up in 2012, or I mean, in 2016, a lot of us brought up the bones had been given back to the hall box. We were all in a tiff about it, and we were told literally by a lot of people, that's fine. They don't got to keep the bones. And we were a myth. We were like, what? And now look where we are with it now. No, they weren't supposed to give back the Hallbuck bones. So we want to follow through with our work, and we want to make sure that we get an answer from the producers to just know where they got the information. It's a good start. Great job, RD. You help us so much. You guys help us too. One thing we try to do different is we try to be a very interactive channel so that when we start researching, instead of completing the research and just coming and doing a news broadcast, we love to bring it in when we're still in the research part so that the armchair sleuths, because you're no different than I am. I sit at my home, I read things on the internet, and I dig deeper and deeper and deeper. And that's how we get this figured out. So we appreciate all the help we can get. All right, guys. With that, we're nearing almost 4:30 my time, so it's time to say, "Oh, from Serbia, hi, Mapco, hi." I'm waving if that counts. I feel kind of nerdy waving, but all right. I love you guys very, very much. And with that, let's go ahead and say it. If you did not do the crime, you should not do the time. Thank you so much. And you guys have a great day.